Hello, everyone. Happy Tuesday. It is Tuesday, August the 12th, 2025, and this is America, Some Assembly Required. Um, Anna has joined us today. I'm going to be bringing her on to stage here in a minute. And we're going to be talking today and continuing our discussion on the amendments to the original 1787 Constitution. We have to remember that 1787 Constitution applied to our republic, but it's a good model for us as we're moving into and starting to think about our international business assemblies, how our where our fences are. Where do we define the line between what we're supposed to do and what they are supposed to be doing for us? And so I think it's important that we understand the Constitution and its amendments, and that we can go forward and be able to um, know just exactly how they are supposed to treat us, which is what the amendments and the Bill of Rights really are about, is how they're supposed to treat us. And in the same way as we assume government roles, how we are supposed to treat the people of our state. So I think that's really important that we really begin to understand and comprehend those concepts and what it really says, what it really means, what the history is of it, and be able to move our governments forward in its international business assembly. So with that, I see Shannon and Clarence are going to join us, I guess, for the first couple minutes, and then we'll move on. So I'm going to add Shannon and Clarence. There's Shannon and Clarence. I like the cut, Shannon.
Well, it got too warm for me, so I cut it all off. It hit 72 degrees one day, and I said that enough of that.
Oh, that's just so warm. So warm. So
Anna's running a few minutes behind, but we'll be here shortly. I was sent to stall.
Okay. All right. Well, that's good. So what we've been talking about is the amendments to the 1787 Constitution, basically the Bill of Rights, right? And so we're up to the Sixth Amendment, and I'm going to bring that on to stage here so that everyone can see it. And just read over it for a minute. So the Sixth Amendment is, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So, what a mouthful, right? And we wish that would happen today, but our administrative courts do not. They violate this Sixth Amendment all the time towards us, the people. And it's, and I think it's an eye opener as we read this as to what we are really supposed to be, as they stated, as our founding fathers stated, enjoy the rights to these speedy public trials. Now, they do try to hurry them along, but in the same aspect, we have people who are out there who are taking and being kind of more or less railroaded into a very, very quick pre-trials or into quick situations where they are not prepared to defend themselves. They're not really sure what they're supposed to do, and they're not allowed anything but corporate defense, meaning a defense attorney and not an actual counselor of law to sit by their side for them to be able to present themselves, not be represented or represented by their corporate staff. And so I think it's really, really important that we understand what our Sixth Amendment really is and does for us. So there she is. I'm going to bring her onto stage. All right. Hi, Anna. Welcome back. Up, I don't have a mic. You're still muted. Let me see if I can unmute you. Nope, it's on your side.
Good morning.
Good morning. Great. Thank you. Welcome back. I'm sorry to hear about Jim. I hope he's doing better. So
We'll get a full report here in about an hour and a half.
good. All right. So what we're doing is I just read through the Sixth Amendment, Anna. Lot to unpack in it, isn't there? And compared to today's courts and our courts, what we need to be making sure we're doing within our assembly courts, there's some good advice in there for our Sixth Amendment.
Yes. Actually, if we were in our correct jurisdiction, there would be absolutely no doubt that the supremacy of the Constitution would be upheld, but we're not in our proper jurisdiction.
Correct. That's correct. So, so as we go along, I pointed out just as you were coming on stage that, you know, the de facto really does violate this in many ways all the time under their maritime administrative courts. And they don't really allow us to present ourselves. They don't give us time to prepare for presentation of our cases. They don't. They really are stack the deck against us, I guess is a better way to present it. And when it comes down to having witnesses bearing testimony against us, they really don't do that either, do they?
Well, that's because the way that their courts are set up, in the municipal courts, you're already guilty. And all that's taking place is you're being sentenced.
Right.
And everything that you say or that you present has no effect because those courts cannot consider the law or the facts. We go in to these courts assuming that they're real courts and that they're operating in common law. And so we bring forward the law and the facts, and they ignore it because that's not the kind of court they are. And because when they're dealing with the so-called 14th Amendment citizen, they have already got a prejudgment against them and can go ahead and sentence them at will. So these are not really courts in the sense that we're thinking of them. They are already set up so that you are guilty until proven innocent, which is a very difficult position to be in. And they just basically steamroll over everything and anything that you might present to them. Because in their court, in their system, they can do that. And because they believe that you are a franchise of their corporation, which gives them the power to deal with you as an internal element of their system.
Right. And when we go into their courts, they usually only offer you, of course, we don't plea, but they only ask you to plea not guilty, no contest, or guilty. And they don't give you your true right of being innocent, of saying you're innocent. And a lot of people don't realize that shifts the burden of proof in their choice and already puts it on that prejudgment path going into their court.
Right, because innocent is not a possibility in their court. They've already done the deed, and they've already declared that you are guilty, a criminal, and that you have the onus as a criminal and slave to the Pope in the magisterial courts. So it's all of your law and all of your evidence and all of your testimony, everything is just moot. And the judge is just sort of sitting there, ho-hum, waiting for you to get through your presentation so that he can levy the sentence he's going to levy anyway, which is guilty.
Right.
You're holding my phone hostage for coffee.
Yes, she is. Pronounce you guilty. Okay. So,
Reminds me of the story about the little boy who was forced to write, "I will not interfere in school anymore," because he was, running competition with the teacher. So he had to go home and write 5,000 times, "I will not talk out loud in school." Well, he's looking around. He sees a little statue of the Virgin Mary. He's a nice Catholic boy going to Catholic school. So he takes the statue, wraps it up in a sock, puts it in his underwear drawer, and the next thing he's writing is, "Dear Jesus, if you ever want to see your mother again."
oh boy. All
Anyway.
right. So, one of the things I always tell our people that if you end up in their court, for whatever reason you end up there, you end up in their court, you always want to state you're innocent and stand on it as an American. They really don't know what to do with that. And it creates a flaw. As I explained in talking about the Fifth Amendment, if we land in their court, our job is to create flaws because they've already judged us guilty. And they're gonna, unless we can convince a jury of
Let's go. Come on, ass pipe out. Come on, dogs.
Unless we can convince a jury of our innocence, then we have to create flaws within those courts and bring up where they are violating our rights as Americans to be able to get into the next round, the appeals round, to hopefully create enough flaws that they can overturn the ruling in their appeals court. And so innocent is one of the first paths towards that, right?
Right. One of the other things that we should note is that those municipal courts aren't supposed to be operating in the states of the Union. They're supposed to be strictly relegated to the District of Columbia.
Mm-hmm.
And
Right.
so, calling them out and asking in a forthright fashion, "What are you doing here?" Where's the authority for a probate court to exist within the states of the Union? They don't have any.
And they pointed out in the Sixth Amendment in the statement that which district shall have been previously ascertained by law, right?
Right. Right.
So, that sort of reminds me of the joke about somebody who is getting their paycheck for the first time and they go, "Who is this FICA and why are they taking money out of my paycheck?" So they're really not supposed to be operating at all, but they more or less usurped our local courts, our mayor courts, and our county courts in terms of their administrative process.
Well, and the other part is that until we call them on it, they get away with it. There's no provision whatsoever for them operating outside the District of Columbia. But what they've done is that they've piggybacked back like fleas on a dog. They have piggybacked on the territorial districts and the territorial courts. And so, strictly speaking, none of those courts should be operating in our states of the Union. The territorial courts are supposed to be strictly limited to territories, and they have no territories anymore since October 1st of 2020. They have no states within the contiguous United States, no territorial states since then, because we finally got our states back into session and the appropriate states voted on the issue, and they formally enrolled the territorial states under the process that is ordained by the Northwest Ordinance. So there are no Western territories anymore. and there should be no territorial courts operating anywhere within the states of the Union. So we've got these courts illegally operating in our states and pretending to serve their employees and dependents, when in fact they are usurping against the public and are actually misaddressing Americans in general, as if we were all their citizenry, and we're not.
Right. And I think it's the core of the Sixth Amendment. It really tries to guarantee to us a fair and a transparent and, basically a mutually adversarial criminal process. So where our individual sovereignty is really preserved within that Sixth Amendment, in that. So this is way outside of their box, as far as the way they're operating against us. Correct?
Correct. And they've had no excuse for it ever since the 1860s. They've been operating in fraud ever since Abraham Lincoln, when he pretended to be the president of the Federation when he was in fact just the federation of the president of a subcontractor, a business basically in the business of providing governmental services and not the government at all. Okay. And this whole situation has been illegal since day one. It's all been founded on fraud, deception, deceit, and other usurpations against the lawful employer and against the public trust. So all of this is null and void, and these courts and their decisions are null and void. And yes, people, in case you hadn't noticed, this also means that the decisions and the executive orders of the presidents misapplied to the general public are null and void. All that those presidents can do or command with their executive orders are the actions of their own employees and dependents. And we are neither an employee nor a dependent seeking asylum. So they are acting way out of line and have been way out of line for a long time.
Right. And also the Sixth Amendment really brings to light the fact that we are supposed to be judged by a jury of our peers, a trial by jury. And that means the people should be more or less local to our county, to our neighborhood, to our city, that they're supposed to be kind of in our local culture.
Well, perhaps even more important, Lisa, they're supposed to be Americans. They're not supposed to be British territorials. They're supposed to be in the right. They're supposed to be in the right political jurisdiction. They're supposed to be operating an American court, and they're not. There's no way possible for them to produce a jury of our peers. And what they do to try to get around it is another deceit. They offer a jury trial, but what we are owed is a trial by jury. A jury trial just means there are 6 people sitting in an enclosure, or 12 people if it's a full jury. They're sitting in an enclosure and they're nodding to whatever the judge says. That's a jury trial. But a trial by jury, in which the jury actually makes the decision, is what we are owed. And we are owed a jury of our peers, which means Americans who are adopting their birthright citizenship status, not a group of British territorial citizenry that has been summoned to arbitrarily rubber stamp whatever the judge says.
Correct. I call that flaw number 3. Flaw number 1 is is when the judge oversteps his jurisdiction and tries to make us part of his jurisdiction and refuses to recognize that we're Americans, not U.S. citizens. Flaw number 2 is trying to make us plea and give up our right to be innocent as Americans and have them prove our guilt, not us prove our innocence. And flaw number 3 is then a trial jury where they are all U.S. citizens. We're an American. It's not a jury of our peers. Most judges will say, same difference. No, I object. That is not the same difference. My political peers are Americans. These are U.S. citizens of a different political class. And so that's flaw number 3 in the court that we create when we go, if we have to be in there, which we really try to stay out of their court, of course. So really 3 really important things if you're going to be going to appeals, because just based on those 3, you can get something thrown out and appealed and overturned. But you know, it's really important that we go in with that knowledge if we have to. But at the same time, in our courts, it also speaks to the way our courts should operate, because we're going to be operating on the fact that our juries are a jury of their peers, and they're going to be asking the questions, making the judgments, and you know, adjudicating whatever the affair is that that's presented before them.
Right.
So,
Well, we get to judge the law and the facts. When it says the law, it means we get to look at the law and see if the law makes sense, to see if the law is fair, to see if the law is properly stated so that its meaning is explicit and not left to interpretation. You know, we get to actually fine-tooth over the law itself and make sure that the law is what it should be. We also get to examine the facts of the case. We're the ones that get to hear all of the material that's been brought forward by the defendant and decide whether the defendant is justified or the plaintiff. As it stands in these courts, the plaintiff always wins.
it's true. And the plaintiff always seems to be the corporation, doesn't it?
Yes. And so otherwise you're expecting the corporation to condemn one of its own franchises and lose money.
Right. Which is why they have a 96% conviction rate.
Right. It's rigged. It's rigged. It's all a setup.
Right.
It should not exist in this country at all, which is what we have to protest en masse and get rid of. But in order to get rid of it, we need to have our own courts up. There needs to be an alternative, and we need to be stressing the fact that we're removing our cases to our courts. Because as soon as our courts are up, anything concerning us becomes a matter for our court to decide, not their court, because of why? The supremacy clause.
Right. That's right. And, you know, very interesting. I mean, they are definitely continuing to push back to see what we know. We keep pushing back and letting them know what we know. Right.
Right.
Because otherwise they're not going to accept anything. They're not just going to say, oh, hey, well, yeah, my bad. You obviously kind of know what you're doing. So never mind. They're not going to do that. They're going to keep pushing just to see where you know what you know and how far you will push it.
I think it's really telling, Lisa, that we've recently had people come forward and simply go into their court and say, I'm not a 14th Amendment citizen. And if you have proof otherwise, bring it forward.
Mm-hmm. Yeah, absolutely. There you go. There you go. So yeah, that's basically our Sixth Amendment. And I don't know if we have much more in that we really need to discuss in terms of international business. Just that, you know, we have to realize that, you know, that's one of the amendments that's there, and really key to our court operations as well.
Well, and our right to remove ourselves from their court system,
Mhm.
you know, because once the law of the land is invoked, it's just a hop, skip, and a jump to get to the soil jurisdiction.
Mhm.
And once you're in the soil jurisdiction, you're totally outside of their ability to meddle with you.
Right. Right. Okay. Well, shall we move on to the Seventh Amendment?
We shall.
Okay. So it says here, in suits at common law, where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. So, $20, that's in today's terms, that isn't very much. It'd be about $700 in 1787 dollars.
Mhm.
And however, when you're facing, for example, we've had some who've gone into court and they'll say, I want a trial by jury, and the judge says, well, we're just going to have a bench trial. No, you're going to deprive me of more than 700. You're going to deprive me more dollars than that. So therefore, I want a trial by jury. And if you push back on it, then they're going to go, okay, well, we'll have a jury trial. That's not the same. Again, it's another flaw that you create, right? And within reminding the judge what his duties are to us in the right of the trial. So with the Seventh Amendment, the other thing that is embedded with that is once we make a decision in our courts, it can't be re-examined, right? The law of the land is final.
Well, the only thing that can lead to a reopening of a case is new information coming forward.
Mhm.
A jury trial cannot be impeached or changed. The result cannot be changed, except that if, for example, you had a jury trial and a man was condemned as a murderer and subjected to life in prison, and then 5 years later the actual murderer is identified. In cases like that, where new information comes forward, a jury trial can be overturned, because the presumption is that if the jury had had all of the facts, they would have been able to find otherwise and would have. So there's just one example of, new information can void a jury trial finding. But that's the only thing that I know of or if you have proof of malicious wrongdoing on the part of a juror or jurors, that could also overturn a jury trial.
Right. And that's an important thing, that as Ohio has opened their courts and had our first few cases, we're all when we're in the mock trial learning mode, we're very open, and we talk about all the details, and we, do all the wonderings and questionings and all of those things. But once our courts are open, it's pretty much mum's the word, right? Until you get into court, because you taint your jury pool when it comes to the actual trial itself. And that's
Right.
where it can be the results of a jury trial nullified, or a trial by jury nullified, because of having your jury pool tainted. So that's a good caution out to many of the assemblies, that when we actually do encounter a case, we can't just go out and talk about it among ourselves. That has to be kind of kept in confidentiality within the courts.
Yes, and within the jury. In some really important cases where there's a loss of life that can be occasioned, which is a judgment that can never be changed. I mean, everything else you can undo. Everything else you can, to some degree or extent, make up for. But in a case where it's a capital crime and someone is going to be hung or otherwise disposed of because of it, it's very important that the juries be sequestered and that there be this confidentiality of the jury and the jury members, as well as whatever the private information may be concerning the case and the individuals involved, because you don't want the public to weigh in on a matter of such importance. It's presumed that the jury is privy to information that the rest of us don't have. And it's inappropriate for a jury member then to go out and start discussing the case with members of the public.
Right. Right.
So
yeah. So I think it's again some real important concepts that we have to leave for our jural assemblies in this amendment. And what washes over the top of me when going through these amendments is how blessed we really were by our founding fathers even in their afterthoughts, and how wise they were, because a lot of these amendments were in reaction to this new governing body, and people were afraid that they would usurp upon them the way the British had usurped upon them, and they wanted to make sure it was very clear that that new government had obligations to the people under these amendments, correct?
right, absolutely. And they realized that they hadn't gotten it right with the first blow, right? So
Right.
they reviewed it and they made corrections to it. And that is very much the role of the American jurisprudence, is to correct errors as you go, as you discover them. This is what we do with appeals courts. This is what we do with the entire justice system in the American system, is to find and correct errors. And that's the idea behind jury nullification too, is that when the legislature writes a law and passes it into law, then the jury gets to go back and examine the law in real life and in real time and determine whether or not it's fair, whether or not it makes clear, explicit sense, and whether or not it's a law that should apply to people. There are so many things that we miss out on, so many corrections and counterbalances and checks to power that we have not been able to exercise because our juries have been functioning in the wrong jurisdiction and have not been able to judge the law and the facts. If they were able to judge the law, there are a lot of these laws that would get thrown out for vagueness.
Right. Yeah. And I think it's really important that we appreciate what this also means to our assemblies on a whole, is that, I hear a lot of assemblies get kind of almost paralysis by analysis,
Right.
and realize that when we put our bones up, what I call the bones, right? The processes and the initial procedures for our assemblies, we're going to be modifying those for years and years and years to come. And the first thing out of the box doesn't have to be 100% correct. We're going to correct it as we go along. That's the course correction that we can make within that, as long as we're staying within our lawful boundaries, right? And this amendment speaks to the very same thing when you talk about nullification of laws. we find out that those laws are not constitutional, or they're not something that we really should or need to adhere to, and that way we can change that law. Our assemblies and its processes and its procedures are all the same. And as you said, get your courts going. I say get your assemblies going in the same way, because it's important that we get up, we get standing, we get elected, we get moving, and then we can go back and say, okay, now that we've done this, what more do we need to add? What do we need to change? What have we learned, right? And our courts do the same.
Right. And when we get back to a point of jury nullification, we'll find that there are a lot of laws that are void for vagueness, a lot of laws that are unconstitutional or nonsensical, a lot of laws that we don't need, okay? And the juries will start throwing them out. And this will give us relief from the 80 million statutory codes and regulations that the subcontractors have created for their own employees.
Right. Right. Like you can't wear shoes of 2 different colors on Tuesday or something.
Yeah, that just, it's insane. 80 million codes and regulations and statutes. Nobody can know what those, can know all of those codes, regulations, and statutes. Nobody can obey 80 million codes, regulations, and statutes. And more to the point, for taxpayers and for people that actually have to live in the real world, who's going to enforce it? Who's going to pay to enforce it? This incredible edifice, this huge, top-heavy conglomeration of rules that have been set up for government employees is ridiculous. It would never have ever happened, except that they've been misaddressing the American public. At the same time, they've been misaddressing employees from other corporations.
Yes, absolutely. Stepping outside of their boundaries, of course.
Yeah.
So
It's a case of usurpation against the Constitution, against their employers, and against the actual law of this country.
all right. Well, we have anything else to say about the Seventh Amendment before we move on to the Eighth?
Well, I think the Seventh Amendment is crucial in a respect that other amendments are not. A lot of people kind of gloss over the Seventh Amendment, and we shouldn't, because we do have a jury of our peers. We do have a requirement here that we need to enforce realistically on these foreign courts. And when we plainly state it, there's no way that they can get around it. The danger is that we don't state these things. We don't make our objections as their court process grinds along, and then we have no right to appeal.
That's right. That's right. I always tell our people, when you're getting ready to state something in court, always say, this is for the record or on the record, and you state your objection or the reason for your objection on the record.
Right.
And make sure that you have a good explanation for whatever that objection is that you are doing, so that when you're challenged by them, you can state what it is that is. But if you never get it on the record, then an appeals court can't review it.
Right.
And that's all they do. They don't interview you. They don't give you a second chance to speak, to object, or anything else. You have to have it on the record.
Right. They only review what's actually on the record. So if you made comments off the record, they don't count.
Right. Right. So, and Anna, it's really interesting that we've seen this in a couple of spots where some of those records have been actually edited when people put things on the record they were not recorded on the record.
Right.
And so it's kind of important too, if you have to go into their court, make sure you have a recording of the proceeding. I don't care if that's a recording pen in your pocket, your cell phone, sitting out recording what's going on, or people in the gallery recording. You need to make sure that you've got a source of your own recording.
I've even gone so far as to bring in a court stenographer.
Mm-hmm. Mm-hmm.
You know, if it's an important enough issue or an important enough case, bring in your own court stenographer. And it's not inexpensive to do, especially if a case is going to drag on for several days. But at the end of the day, you've got an official court recording.
Mm-hmm. Right. Yeah, there are people who like to poke that bear and want to try to go in and do it, but they've got to realize that the DAC is already stacked against you from the Sixth Amendment, essentially, and their presumption of us as 14th Amendment citizens. And our job then is really to create the flaws that's going to go into appeals that gets it appealed, or gets it brought into our courts so that we can do a nullification and based on facts and law.
The other thing is that we often can back them into a court. We can back a court into a corner where they just say, dismissed.
Right.
Because they realize that they're in a corner and they say, well, not going to go there. And they dismiss it in favor of their own bond, you see.
Mm-hmm.
The rule in their court is whoever controls the bond controls the case and the court. So, once you have got them in a position where you're in control of the bond, they just give up and say, oh, we're sorry, we didn't mean to bother you, Mrs. Fun Rights. They become very pliable at that point.
Right.
Now, I have yet to figure out what to do when they beat feet and run for it. There needs to be a reply for when they do that, because we're at a point now where we regularly get the people that they've hired, these hired jurists, to capitulate. They get to a certain point and the stakes are too high, and they decide that, oh, we don't want to deal with this particular person or this particular issue. And then they will dismiss the whole proceedings. They'll dismiss the whole thing, all the way back to the summons and all of it. It's gone, right?
Yeah, and they remove it.
They remove it.
Anymore. Mm-hmm.
So now suddenly they even will exonerate cases and completely erase the record that they ever happened. Okay. So there are a lot of cases like that now where we push them to the brink and over the brink, and they just say, oh, well, case dismissed. For no explanation. I mean, you'll just be sitting there 1 second, and then the next second the judge walks out and bangs down his gavel, case dismissed. Next case. And you're left standing there going, blah, 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 what? Why was it dismissed?
Is that dismissed with
prejudice?
With
Yeah, is it dismissed with prejudice? Is it, why is it being dismissed? We want to know, right? Curious people want to know, and it doesn't really matter whether the dismissal is in our favor or not. We want to know why the case was dismissed, and they will not tell you.
Right.
And then on top of that, you've got the dismissal order, right? And the dismissal order says nothing about the reasons for the dismissal, which gives an appearance that the law may have been broken, and you don't even have an explanation why.
Mm-hmm.
So we really do need to work on not only a silver bullet to wave off their attempts to summon us and solicit our business, we also need to find a reply to dismissals which are not explicitly detailed.
Mhm.
Because this is another way that they keep from full disclosure. If they were fully disclosing their process, they couldn't carry on with their process. This is a way that they do not provide disclosure on dismissals.
Mhm. Right. Right. Okay. Well, I think it's really important, and our General Assembly should be really looking at the Sixth and Seventh Amendments, making sure that, we're covering our bases in terms of our General Assembly, but then also providing education to people so that they know what to do or how to proceed if they have to end up going into court. Many times I hear people go, well, what I need is I need a writ, or I need to write, this affidavit, or I said, are you playing their game? Because the rules are already stacked against you in their game. You're going to
Right.
play by their game. You're going to lose. You've already lost. But if you play the game and you create the flaws, you have a chance of being able to create enough flaws and introduce enough concepts that you can win the game in the end. May not win the first round of the battle, but you might win the war in the end.
Right. Right.
So,
Well, the end game for me is to get rid of their courts.
I'm good with that. I'm good with half the time they don't know the law anyhow. They
Right.
really don't know the law. And so how do you expect not only them to judge what the law is, but the juries to go along with what the law is? And half the time they won't even let the juries know what the law is. So
Right. Right. It's a useless commercial procedure being presented as if it were a court, and it's not. It's a commercial judgment function that has to do with commercial corporations. And you're not a commercial corporation. You're not functioning as a commercial corporation. You're not aware of the law of commerce. And why should you be bothered and summoned and basically tricked into participating in a court procedure that doesn't concern you? It concerns a franchise of one of their corporations that they have named after you without your knowledge or permission.
So I think the Southerners had it right after the Civil War when they nicknamed it the carpetbagger courts.
Right.
And they were just continuations of the Star Chambers of England, and essentially what they are.
Right. It's basically an illegal court system.
Mm-hmm.
So
it's especially unlawful.
especially. Well, if we were all corporations, and if we were knowledgeably functioning and choosing to function as corporations, and if we were actually involved in international or global commerce, then there would be a reason that we should then be expected to function in those courts and to deal with their conventions and their UCC law and all the rest of it. But we're not. We're just average people off the street who have no reason or cause to know how corporations are adjudicated. We have no reason to know that law.
Mm-hmm. Right. Most of us have never had to operate as a corporation, so we've never been exposed to what the corporate law really is.
Right. And I believe as we get a little bit further on here, as we look at the 11th Amendment, we'll be seeing more information about this particular subject.
Yes, very much so. All right. Well, are we ready for the Eighth Amendment? Because it really does apply to our discussion. It says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So, Anna, why can they charge somebody a $250,000 bail and place them in a jail cell until they either get their 10% or they pay their bond? How is it that they can do that?
Well, it's when you use words like excessive, it opens a door to interpretation. And what would have been grossly excessive in 1901 is not excessive in 2001. It's the times change, and the definition of excessive changes with it. As you have noted, they had the jury trials are owed to matters that are in controversy in excess of $20. Well, $20 in 1789 was worth a great deal more than $20 today.
Correct.
And so the same sorts of things apply to what's excessive. What would be considered excessive? Well, there is no stipulation of what excessive means in the Constitution. The common sense of the issue has shifted over 250 years to a point where what would have been considered excessive in 1789 is not considered excessive in 2025. And that's part of the problem that we have, is that the Supreme Court is the only body that is able to make a determination on the meaning of the Constitution. And so without some sort of more specific guidelines, such as excessive shall be in anything in excess of 1/1000th of the person's annual income, or 1/100th of the person's annual income. That would give you something solid that you could look at and say, okay, well, a bail of 250,000 is excessive for Joe the carpenter, but it's not excessive for Nelson Rockefeller.
Right.
You see. But we don't have that kind of language, and we don't have that kind of a description of what excessive would mean embedded in the actual amendment.
Right.
So it leaves it up to the discretion of the judge to depend, and determine what excessive bail shall be.
Right. Well, that speaks to the no common sense that is pervasive within our court system, because the intent of the original founders was, who wrote these amendments, was that it would be no more than a week's wage.
Right.
And that was really their intent in how to write in what was excessive.
Right. And we can look that up if we want to dig through the Federalist Papers and other sources. And that's ultimately what the Supreme Court has to do too when rendering a decision. But I'm just saying that the language as stated does not allow us to come to a rapid and easy and consensual agreement about what excessive might be in any given case.
Right. Okay. All right. Well, we've got a few questions, Anna, and then I'm going to let you go ahead and answer some questions. And then I think we'll pretty much call it a day, because I know you've got other things you want to move on to. So let's see. All right. This might be germane to what we've been talking about. So what is Trump trying to do by changing the name of Washington, D.C. to a district of America, or district?
Well, the District of Columbia was created specifically to give our subcontractors, our federal subcontractors, a place to conduct their business. Okay. Now we've since found out that this had religious overtones that were related to the Roman Catholic Church. Columbia is one of the names of Astarte, Isis, Semiramis, Sybil, Ashtoreth. These were the names of a goddess. Isis is another one of her names. That was part of the ancient gods of the Middle East, and which had been brought forward over time. And we are not aware of this, of course. And 99.9% of the population was never aware that Columbia was invoking a goddess of an ancient religion, and a very venal religion, as it turns out. And so there's been pushback. People want to get rid of references to Columbia because that's the name of this profane goddess. And so changing it from Washington District of Columbia to Washington District of America is part of that pushback. You have to remember that a good deal of what's been going on the last 10, 15 years has been the discovery of this death cult and of the underlying language, the meaning of so many of these things that nobody suspected. So getting rid of Columbia and all references is a good thing, because it's turning our back on the evils of that particular death cult religion, if you can call it a religion, that has been holding sway within the District of Columbia from the founding to today. So I assume that that is a good part of what Mr. Trump is trying to accomplish, is to get rid of that reference and get rid of that infiltration of that ancient religion into our government.
Okay. All right. So that's really the only comment that we have today, or question that we had today, that were in the chat. So if there aren't any more questions, then I think we're done for the day.
Look, I'm already wearing mine.
There you go.
These are my moving furniture duds. We're still deep in the dregs of moving our office space.
I can see that. I notice. So, all right. Well, you can get allowed to go back to the grime. Oh, I've got another question. One question that popped up here at the end. Is it allowable to hold court for both criminal and civil charges?
Well, yes, but you have to call a different court, a different group of jurors for each charge, whether it's criminal or civil. They're actually two different courts in a sense. And so you wouldn't want the same people making judgment in a civil affair that you do in a criminal affair. And typically what happens is that you bring the civil issue forward, and if in the case of the civil discovery you find a criminal charge, then it will be referred to a criminal adjudication, a form of criminal adjudication. If you go at it the other way and you wind up with a criminal offense being brought, and then there are civil charges that resulted from the crime, then the crime court has the ability to make a decision about damages and those sorts of things that are attendant upon a finding of criminality. I guess it matters which side of the court you're entering, right?
That's right.
So You will either have two courts considering it because it came through a civil manner and became a criminal court matter, or you will start out in the criminal court and you will get a judgment of criminal damages, which would be the same as the civil damages.
Right. Yes. All right. And that's the way Ohio's courts are set up within our kind of our division between our civil court and our criminal court. They're set up that way so that that can be placed from, you know, if it's civil and you discover a criminal issue in it, then you're going to take that on to criminal court.
Right. You're going to refer it.
You're going to refer it on. Yeah, it gets automatically referred on. And there's paper, you know, we tried to anticipate some of those things that would be the formalization of that on a piece of paper to take that into the criminal court. And the same way as well at the end of a criminal court, if there's civil issues that have arisen, where you can pass that back and make that enforceable by the civil court. So if there's damages, you know, if it's criminal and there's damages, then that becomes the damages part of it becomes part of not only the sentencing, but the civil side of recouping those damages.
I just had a question back to our audience.
Oh, good.
Do you believe that we should enforce the Sixth Amendment in every case that comes before any court in this country?
I do.
I do too. When it says it's the supreme law of the land and the land is under our feet, I believe that we have an obligation to enforce the Constitution on every court, regardless of the subject matter jurisdiction.
For the record, the Sixth Amendment here would apply for the record, right?
Right. Right. Exactly.
And therefore, in the matter of subject matter jurisdiction,
right, when it's right here, this is the law and this is the land, and you know it doesn't really matter if your court is on dry dock here on land, it's still on land. Right.
That's right. Exactly.
Okay, guys.
All right.
Hugs and kisses, everybody.
Thanks for joining us. We appreciate it. We'll pick up next week. Okay. All right. We'll see ya.
Take care, guys.
All right. Bye-bye.